pretrial conference coming up? If so, you definitely want to watch this because we're going to go through what you need to know and how you need to prepare. Hopefully, you're one of the lucky ones that are able to settle their case and go to judgment at the pretrial conference instead of going through the actual hearing. But if you're not, I want to just take you through the steps so that you know what to expect and you can be prepared for that. So the first thing, you will receive a notice from the court that lays out exactly what you need to do. So you want to be aware of that because if you don't abide by that, the court can take a number of actions, including penalizing you by asserting fees or even not hearing your case. Prior to the pretrial conference, it's mandatory to have what we refer to as a four-way meeting. And it's called that because typically each party, that's two people, each of them have an attorney. So now we have four people. So it's a required sit-down meeting. With the pandemic, a lot of times now these happen via Zoom or some sort of virtual conferencing. But before the pandemic, it was all in person, and I think we're starting to head back there. So you meet with everyone and you talk about the issues in your case. If you utilize that pretrial conference and you can come to a full settlement agreement, great. All you have to do is write everything up, present it to the court, and you are done at your pretrial conference. If you can't, then the next step that comes is that a memo needs to be drafted. Now, I honestly believe that your pretrial memo is incredibly important. I've seen some attorneys that just put a minimal amount of work into it because sometimes I think possibly they don't want to lay all their cards on the table, or maybe they're just not fully prepared. I don't know. But we actually put a lot of work into our memos because this is your chance to really have the court first hear the ins and outs of your case. It's the opportunity you've had during the pendency where if you went in for a motion for temporary orders, there might have been 10 to 15 minutes of argument that has gotten in front of the court. There might be all this back and forth that's gone on that you want the court to understand in order to hear your case and come to a decision. The pretrial conference is your opportunity to do that, and we utilize our memos to do that. So we'll write out what's happened in the case, what the issues are that remain contested, and why you should get what you're looking for in relation to those issues. Now, on top of that, there's a number of other things that need to be included in that memo, like if the case is going to go to trial, how many witnesses you're going to call, who they are, what type of exhibits that you might be presenting at trial, along with a number of other things. Again, check that notice. But on the day of your hearing, if you are not able to come to an agreement, you will go in front of the judge. Now, the majority of times, the judge does take the time to read the memo. And I always appreciate that because we put a lot of work into our memo. So it's really nice when a judge walks into a hearing prepared. However, there are times maybe the court is just too busy, or I don't want to say anything bad about the judge, but maybe they just don't read it. So then it's really important to not only have your memo, but be prepared to argue it. If the judge walks in, and this happens particularly with a few judges that I can think of off the top of my head, we know they've read it and they tell us they've read it and they don't want to hear any arguments. They want to just jump to the issues in the case. Other judges will walk in and say, please present your argument, whether or not they've read. Now, I might say, Your Honor, have you read the pretrial memo? That way I have a better idea of whether I need to go through every single issue or whether I can really focus on the main issues that are in front of the court. Sometimes they don't tell me and they just say to argue. We can't control what a judge does. But that's your opportunity to kind of lay everything out that's important to you in order to get the result that you're looking for. Now, the pretrial is also incredibly important because a lot of times the judge is going to give the parties feedback. Now, they're usually very clear that what they're saying isn't necessarily the outcome that they would decide if the case goes to trial. And there's a lot of reasons for that. What you may be presenting And unfortunately, we hear this a lot. The other side just lies. They might say things that just aren't true, or they might say things that are completely contradictory to what is actually in evidence or what we have documentation to prove. So there may be reasons that a judge comes back and gives feedback that could be very different at trial. You might have your case all set on this one particular piece of evidence that is incredibly important to your issue. If that can't come in at trial, the judge isn't going to hear it. So it could be a completely different result. So at the pretrial conference, the judge will give you some feedback based on what they're hearing. Again, it doesn't mean that it's going to be the outcome, but it can usually give you a very good idea of where the judge is going to fall. And the reason that's important is because then you can do a cost-benefit analysis of what you are continuing to fight for with what you're getting out of it and how much you're going to pay to get there. Trial can be really expensive. So you want to hear the feedback and be able to utilize that to make an educated decision of whether you're going to settle or whether you're going to move forward. It can also be incredibly important because there might be one or two sticking issues that once you get the feedback from the court, if the two of you just agree, okay, this is what the judge said, so this is what we're going to agree to, that may allow you to fully settle the case. And that's one of the most important things for the pretrial. Not only do you have to get through it in order to move forward to trial, but it's really a tool to help you settle when the case remains contested. Now, you will have a meeting with your attorney to strategize and make sure that we are on the same page with what you're looking for so we can prepare all of that. A lot of people think that the pretrial is similar to a trial, and they think that's going to be the end of the day. It's not. It is very different. Even though it has the word trial in it, it also has the word pre. It is not the trial. It's just a conference to get you there. We've had some people call us and they say, we have our trial coming up, and then we find out it's the pretrial. Two totally different things. So you won't get a final judgment unless there's an agreement to do so, but you should be able to expect that you're going to get some really valuable feedback from the court. So you want to be prepared, you want to make sure you have everything, and you want to make sure that you're communicating with your attorney, again, to make sure you are on the same page.